Welcome to this webinar presented by Australia's National Research Organisation for Women's Safety. We've entitled this Punishment, Protection or Prevention, the Role of the Law in Domestic and Family Violence. I want to thank ANROWS for bringing together this fabulous panel and to acknowledge the traditional owners of the land where we have gathered for the filming of this webinar, the Turrbal and Jagera peoples, and pay respects to them and their elders past, present and emerging. We have fabulous participants involved in the webinar today. I'm firstly going to introduce each one and just let you know where they come from, and then each participant is going to spend a few minutes telling you about their key concerns in relation to this issue. After that, we'll move into a conversation format, and I'm sure that you're going to find this a fascinating exploration of how the law deals and doesn't deal with domestic and family violence. So to introduce the panel, I'm going to start with, on my left here, Professor Lee Goodmark, who is the Professor of Law and Co-Director of the Clinical Law Program at the University of Maryland Carey School of Law in the United States. On my other side is Thelma Schwartz, Principal Legal Officer of the Queensland Indigenous Family Violence Legal Service. Next to Thelma is Dr. Heather Nancarrow, I'm sure well known to most of you, the CEO of ANROWS. Over on this side, we have Associate Professor Stella Tarrant, who's at the University of Western Australian Law School. And finally, we have Acting Magistrate Wendy Cull, who is acting in a range of places as a magistrate at the moment and has been in many places throughout her legal life and brings much experience. So I'm now going to invite each of the participants to tell us in about 2 to 3 minutes what their absolute key issues are in relation to the research or experience that they're bringing to this discussion. And so firstly, to turn to Lee and to ask her about her experience in researching and working in the legal system in the United States and some of the issues around how domestic and family violence is being dealt with there. Lee, thank you.
Thank you, and thank you so much to ANROWS for inviting me to be part of this webinar. My work is as a lawyer on behalf of people subjected to abuse. It's work that I've done for the last 25 years, and I say that because the writing that I do is informed by my work as a lawyer. And so I've written a book that came out this year called Decriminalizing Domestic Violence, a Balanced Policy Approach to Intimate Partner Violence. And in that book, I argue that in the United States, the primary response to intimate partner violence is through the criminal legal system, that we do that both through our focus on the criminal legal system and the way that we fund the criminal legal system, and that response is not working. And by working, what I mean is that rates of domestic violence are not lower as a result of the criminalization of intimate partner violence, that criminalization is not deterring intimate partner violence, that it in fact spurs some of the conditions that cause intimate partner violence by using shame as punishment, by depriving people of work and other economic benefits, by inflicting trauma upon the people that it's trying to punish, and that it has serious unintended consequences for the people that it was meant to benefit, in that arrest rates of women have increased significantly since the inception of some of these laws around criminalization, and that the criminalization of survival has become a serious problem in the United States. So in the Australian context, although criminalization is not here the primary response, there is some purchase behind these ideas, both in thinking about the overlap between the criminal and civil response and the ways in which women are being disproportionately affected by criminalization.
Thanks, Lee. And I think that what you're raising here is so interesting for us because there has been a different approach taken there, but nonetheless, this is not completely new either to us, and it is part of the Australian response. And to have your insights into that is going to be so very important. Thelma, I was going to ask you next what you see as being the critical issues in the work that you're doing, particularly you're working there in North Queensland, you're working in the Indigenous community, but you see broadly what goes on in relation to domestic violence. And what are the key issues that you'd like to bring to the attention of people?
Thank you, Zoe, and thank you, ANROWS, for having me here today. I think the key issues when we're talking about Aboriginal and Torres Strait Islander people and their intersectionality with a criminal justice system and a civil system response is that neither system response is beneficial. In that regard, you can look to the significant overrepresentation of Aboriginal and Torres Strait Islander men, and especially the growing rate of incarceration rates of Aboriginal and Torres Strait Islander women in our criminal justice system. Neither the criminal nor the civil system are adequately capable of addressing the underlying social issues as to why Aboriginal and Torres Strait Islander people come into contact with the justice systems in the first place. The creation of criminal sanction then leads to the other consequences or unintended consequences of, turning a victim survivor of domestic and family violence, supporting her in a domestic and family violence civil process, and then penalising her in the child protection system where she is deprived of her children on the basis that she's failed to adequately protect them and shield them from domestic and family violence.
Thanks, Thelma. And I think you've introduced yet another complexity of the way that these systems work together. It's not just, I like that Lee talks about the criminal legal system, not the criminal justice system. So we have the criminal legal system, we have the civil system with protection orders, and of course we have the overlap into the child protection system and the family law system as well, of course, which is where I tend to do my research. So, yes. Heather, if I could turn to you now, and if you could talk to us about what you see perhaps as, well, what are some of the ways forward, having heard some of the issues being raised already, thought we might start to look at some possible ways forward that we can talk to in more detail later.
Sure, thanks Zoe, and thanks to the panel members for being part of this discussion for ANROWS. So my research interest in my recently published book, Unintended Consequences of Domestic Violence Law, actually brings together a couple of the themes that have already been raised by Lee and by Thelma. It's particularly examining the unintended consequences of civil domestic violence law, which is actually quasi-criminal law because of the criminal nature of breaches of domestic violence, civil domestic violence protection orders. What I think we need to be doing, what I call for in my book, is a distinction between coercive controlling violence, where we know that the gender inequality is the primary driver of coercive control or gender-based violence. However, we also need to pay attention to other forms of violence in family relationships and including in intimate partner relationships that are not about coercive control, and where the drivers of that violence are some of the social determinants that Thelma has referred to already. We need to look at the way in which we can address racial and socioeconomic inequality, which are contributing to high rates of violence in Aboriginal and Torres Strait Islander communities. And in fact, applying a criminal justice response or a criminal legal response to some forms of violence is actually tantamount to punishing people for violence perpetrated on them by the state. And I think that we need to make a distinction between coercive and non-coercive controlling violence and identify what is the most appropriate response in those different forms.
Thanks, Heather. And we will take an opportunity to come back to some of those solutions. And I suppose that I think underlying a lot of what people are talking about is the fact that the law is such a blunt way of dealing with what is really a set of social issues. And when we continue to use the law at the end of the road all the time, we're missing really the issues that are the critical ones. Thank you. I will now turn to Stella and ask her to let us know about some of the work that she's been doing and some key ideas that we can explore later. Stella, you've been particularly looking at the situation when the primary victim of domestic violence becomes a perpetrator of very serious violence and then finds themselves at the very serious end of the criminal legal system, as I'm now going to call it.
Right, thank you, Zoe, and thanks for inviting me to the panel. With Professor Julia Tolney and I have recently done some work for ANROWS and produced a report that was published in June this year. It follows from work that both of us have done over many years. So the context of the work that we're doing in this instance concentrates on, as Zoe has said, women who find themselves charged with a very serious criminal offence, primarily homicide. So rather than be perpetrators and find themselves in the criminal justice system, they've responded to perpetration of abuse and find themselves charged with offences of homicide. And the context of that report and that work was that in Australia, the general historical trajectory has been that no access to self-defence was available for women in that circumstance 30, 40 years ago. Then provocation and other defences became partially available, and they were partial defences that brought convictions down to manslaughter. And then in the last 20 years or so, the focus has been on defences that are constructed basically as self-defence. So that's the context that we've been looking at. With those law reforms that have been mainly and significantly legislative law reforms, the change hasn't occurred significantly in the cases or the results of the cases. Having said that, there are more manslaughter convictions and less murder convictions, and there are a few acquittals. So some change has happened, but not as intended by the legislative reforms. So the work that we did was to look into why, and we used one case as an exemplar to look into exactly how the justice system at that point is working for women who are charged. And what we've come up with is based on a construct of violence that could be used by courts that has been endorsed by the Family Violence Death Review Committee in New Zealand. And it's a social entrapment model of violence that has three dimensions, that is based on the idea of coercive control, but then has a second dimension of responses to violence, and thirdly, a dimension of questioning about the structural inequities that a woman has been experiencing as part of the violence that she's been responding to. So it's designed to broaden and bring structural questions into the questions and definitions and ideas of violence into the courts as they're being dealt with. I think there's probably enough.
Yes, thanks, Stella. We'll come back
to it.
We'll come back and explore some of those, because I think those three dimensions that you've mentioned are representative of some of the issues that people are going to talk through. There is a theme already emerging, though, I think very clearly that each person, from the perspective that they've discussed so far, is saying that so many of the things that we have tried within the law, violence against women is still occurring. We're not seeing a reduction in any significant level of this. And so it's no secret that these ideas are still not working. But we also know we've come a long way from when perhaps these ideas first came under discussion. And we'll come back to that a bit more as our discussion continues. And finally, to introduce from the panel, Wendy, who is going to initially give us a bit of an overview of what it's like to be on the bench on a day in the Domestic Violence Court in Queensland, which is not totally different to around Australia, but while we continue to have this jurisdictional battles we do in Australia, of course, neither is it the same as happens everywhere. So, Wendy.
Oh, thank you, Zoe. Thank you for including me in the panel. I'm speaking on the basis of my experience as a magistrate, and certainly not on behalf of the court. Domestic violence applications in the Magistrates' Court are not all gender-based violence matters. we deal with very long call-over lists, up to 50 matters a day, preferably not more than 30. And they fall into a number of categories. Sibling disputes, parent and child, by which I mean normally an aggrieved older parent, a young child, usually because of drug issues, and also necessary care of children by grandparents, and short and long-term couple relationships, both same-sex and heterosexual. The regime's statute-based, and that means that magistrates can only exercise powers in accordance with the Domestic and Family Violence Act in Queensland, and of course legislation differs from state to state. Our legislation focuses on prevention. That's about setting boundaries and reminding people of their obligations in a domestic situation. It's a court that's in the civil, not the criminal jurisdiction, and therefore decisions are made on balance of probability rather than to the criminal standard. It's an offence for a party to a proceeding to state anything false in an application, so the courts rely on those preliminary statements to make temporary orders. Clearly there's a need for procedural fairness or natural justice, and respondent parties must be given an opportunity to be heard. Breach of an order is an offence which is then dealt with in the criminal jurisdiction of the court. The way in which the cases are dealt with depends to a very large extent on the number of matters that are on a call-over list, particularly the availability of duty lawyers and domestic violence workers in the court, and the availability of resources, and those are for both victims and perpetrators. And by resources, I'm talking about capacity to refer on the spot to relevant counselling services, women's refuges, drug and alcohol services, and these will differ from court to court and area to area. The vast majority of orders made in the Queensland courts are made by consent of the respondent or ex parte, where a respondent's been served and doesn't even bother to turn up to court to challenge what's been said. In busy courts, the applications are most often split into two lists, police and private applications. And the applications by police will be made where they've been called out to a location, or where, less frequently, an aggrieved person comes straight to the police station, leaving the scene where violence has occurred. Police in Queensland can issue what's called a PPN, a police protection notice, and that takes immediate effect. Thorough preparation of applications is the most crucial thing for our court. Magistrates can only assess the information that they're given, so generalised allegations are of very, very little use. Domestic violence workers and lawyers assisting applicants will set out chronologies of incidents with dates, times, details, text messages, phone records to support the application. And it's the availability of these lawyers in the court, which are a factor right outside the control of the court or the magistrate, that makes an enormous difference to outcomes. Many of the private applications, as has already been mentioned, overlap family law matters. Our orders can provide exceptions for contact between respondent and aggrieved that's in accordance with a family law order, but magistrates sitting in the domestic violence jurisdiction can't make orders about parenting or long-term financial or property matters. We do frequently make an order that one party leave a place of residence, what's called an ouster order, but we can't make orders about payment of rent or other money. Another major factor in our courts is the cultural diversity of the people who appear. In many cases, cultural practices are inconsistent with social norms that underpin the domestic violence legislation. Use of interpreters to understand parties and explain orders is critically important, but it can be very slow, and it's stressful for a sitting magistrate when you know there's a long list of matters to get through and dozens of people sitting outside the courtroom. The courts are greatly assisted where we have police liaison officers who come from the same community as parties, and they can interpret and clarify issues. In my experience, and this is in the Indigenous context, community justice groups in remote Indigenous communities provide an invaluable service. Empowerment and training of community justice group members so that they can exercise their role to its fullest potential is extremely important in my view. So in short, the domestic violence legislative scheme as I know it depends for its successful operation on the support of the people who work in the area and the provision of resources, especially legal assistance, housing and counselling services. That's a brief summary.
A brief summary of a day in the life of Wendy.
How I see it.
Thank you very much. I think that brings to light just something of the reality of the legal system, and for those who work on your side of the bench and on the other side, the people who are involved. And I think that idea that you've brought to our attention at the end, that a legal system is such a small part, really, of an entire structure that is trying to work towards these ends of ending and reducing domestic and family violence. But it is actually so dependent on the particular individuals that operate in any community, in any place. And of course, I think for a long time, people who've worked in this field have talked about ideas like a coordinated response to domestic violence. And in a big picture sense, we're talking about people working together and knowing what each other are doing and understanding each other's roles and providing consistent messages. So thank you. We are now going to open up to more of a conversation, and we'll go back to some of these ideas, open them up a bit more and invite other panel members to comment on key issues raised by each person. But perhaps before I do that, I should introduce myself, which I don't recall doing. So my name is Zoe Rathis, and I'm at the Griffith University School of Law, and I come to this with a history in domestic and family violence, both working on the ground at the Women's Legal Service in Queensland for many years, and as a researcher, I guess, particularly in relation to what Stella is talking about, women who have killed abusive partners, but also the family law system. So you might see me looking at some of those issues as I ask questions. To begin our more open conversation then, Lee, I wanted to start with you as our international visitor. We're all thrilled to have you here. And I wanted you just to talk a bit more about that issue of the way in which the United States has chosen that path of criminal legal system as the way of dealing with domestic violence, and looking at some of your work. And I think that for those of you who are as old as some of us at this table, Heather, and I'm not looking at you, who've been working in domestic violence for a very, very long time, certainly there is that allegiance between police and people working with victims, and between perhaps law and order aspects of a legal system that have always been slightly uncomfortable bedfellows in this argument. And now we see, I think, out of Lee's research, how some of this plays out.
Sure. So in the United States, if you go back to, say, the 1960s and the 1970s, and you look at the police training manuals of the time, what you see is a directive to police officers not to intervene in domestic violence cases, that they were family matters, that they were private matters, and that the appropriate response of police officers was to tell the offending partner, who was at that time always a husband and always a man, to take a walk around the block. And that's not inconsistent with the response really in a lot of countries around the world, where domestic violence was very much seen as a private family matter and not the province of the state. Well, in the United States, in the 1970s and going into the 1980s, several things happened that made the anti-violence community in the United States really turn to the criminal legal system. And three things happened in 1984 that were particularly important, but there was advocacy going on prior to that time around greater involvement with the criminal legal system. But for us in 1984, these three things happened. One was that the Attorney General Task Force on Family Violence came out with a report that said this is a criminal problem, it requires a criminal solution, which was the first time that our federal government had ever said this was a criminal system problem. The second thing that happened, which is relevant, again, in every place that uses arrest policy, is that research came out that suggested that arrests would lead to decreased domestic violence. So Lawrence Sherman and Richard Burke came out with a study in 1984 that said arrest deters domestic violence. And though they cautioned that the study needed to be replicated before we could make any conclusions about the impact of arrest, jurisdictions across the country looked at that to say, this may be one of the answers we've been looking for. The third thing that happened in the U.S. was that there was a very high-profile case called Thurman versus City of Torrington, Connecticut, in which Tracy Thurman's husband, Charles, had been abusing her for years with impunity. Police refused to intervene, which led to an incident where he repeatedly stabbed her and then dropped their small child on top of her while the police watched. Tracy Thurman won a multi-million-dollar judgment against the city of Torrington, Connecticut for its failure to intervene. And jurisdictions across the country asked, how do we avoid this liability? Because we don't want to be on the hook for multi-million-dollar judgments. Those three things really set us down this path towards criminalization. And I should be clear what I mean when I say criminalization. I don't mean passing more criminal laws, though that did happen, right? In Commonwealth countries, we'd had the common law of assault for thousands of years. That may be an exaggeration. So we've always, a long time. We've always had the capacity to bring these cases into the criminal legal system. Really what changed was process, police process and prosecutorial process. In terms of police, what happened was that one, police were able to make warrantless arrests in cases of intimate partner violence, and two, police discretion not to make an arrest was taken because the concern was that when police had discretion, they were failing to make arrests. And that's consistent in the Australian context as well. The United States adopted pro-arrest and mandatory arrest policies. Australia has as well. And not surprisingly, arrest rates went up. So then the anti-violence community looked at prosecutors and said, well, why aren't you making prosecutions? If we're making all these arrests, why aren't rates of prosecution going up? And prosecutors said, well, we can't because our star witness won't cooperate.
Can I stop you there?
Of course.
Because I think that the next step of what you're going to talk about is what goes wrong. Having looked at some of the appalling stories that you have reported about the very aggressive strategies of prosecutors, and I'm going to come back to that. I just think that for an audience who's watched the development of domestic and family violence processes in Australia, policy development, legal developments, it is just interesting to see that although there's been influence and a lot of discussion between the two countries and other nations as well, that we have gone down a slightly different path. And I just wondered if anyone wanted to make a comment on that. And Heather, I'm just thinking of our shared history on that journey, and the time that Lee is talking about is the time almost exactly when you and I started to, you in a refuge, me as an article clerk, to work with this. What do you think about that? Why did we end up taking these different courses, do you think?
Well, the task force in Queensland actually examined the option of a criminal response in the first instance and determined that there was already existing criminal law, as Lee's pointed out, that wasn't effective, and that it also isn't an immediate. Even if we could make the criminal law more effective, it's not going to be as immediate as a civil law response, and so women theoretically could get an immediate protection in place in the civil system compared to the criminal justice system. So that's one of the reasons why here in Australia we went for a civil response in the first instance rather than criminal law. I think what's really interesting though is regardless of whether we focus on criminal or civil, we've got the same problems, and we're still motivated by removing police discretion, whether it's to make application, removing victim agency in terms of decisions around what they're doing, and these are the things that have unintended consequences, whether it's in the criminal jurisdiction or civil. So I think it's what's interesting to me is that the problems that we have are regardless of the jurisdiction in which the law is operating, and that we need to address the processes and outcomes, regardless of what the system is. They're both leading to unintended consequences, and partly because what I argue is that we have failed to take account of, we've shaped it around a concept of coercive controlling violence, and just to explain for those who don't know, Evan Starks describes this as an attack on autonomy, liberty and equality, or an attack on personhood. So once you try to achieve a general control over the life of another person, remove their personhood, that is coercive control. Not all violence in relationships is that kind of coercive control, but our system has been designed to address that particular kind of violence. Whether or not it does it, well, it doesn't do it very well either, but that's what it was designed to do, and therefore we have these particular police powers and court powers that assume that the perpetrator is a coercive controlling perpetrator and that the victim is a subjugated and relatively powerless person. In reality, many victims of, partners or people who are engaged in violence in relationships, A, it's not about coercive control. B, it's certainly the women aren't always, or the victim, if you like, is not always a powerless, subjugated person.
Yes.
And yet that's what the system's been designed to do. And I think, although Australia hasn't relied solely on the legal system as a response, I think we've invested too much and relied too heavily on it. And that's been to the detriment of people affected by violence, and particularly those where it's not coercive controlling violence, but that's been the predominant response. And it has not only not helped many women who this law was designed to protect, but it's actually been harmful for many women, bringing them into the criminal justice system, but also having a range of other unintended consequences in terms of social and economic security.
I'm going to
come back to those points, sure.
There, because I think that, yes. So, but what I'd like to do is to just, Stella, you want to, I think I should come to you then if you want to comment on something here. Yes, please. We'll come back.
I just thought to say that I actually see the landscape a bit differently from that, and I, in the context that I've been looking at and spanning out from there, that I think what I see in the cases that I'm reading and studying is that the courts are still looking to physical violence as violence. Yeah. They're understanding incidents of physical violence as violence, and if there's not that violence, then we're not seeing violence. I mean, that was, and so I think the concept can sometimes be talked about, coercive control in the courts, but I don't think there's an understanding of coercive control. Yeah. And so I think a problem, and then I think I see the unintended consequences of the proactive arresting or the proactive action on assault charging, for example, comes again from physical responses. So if we see a woman physically responding, then we see that person as a perpetrator and an offender, rather than seeing the whole picture and seeing that that person can be ongoing. So in that regard, I see it as I see it sort of differently.
I think we actually agree, Stella, and perhaps I just need to expand a little bit on my conceptualisation of coercive control, which includes physical.
Can we come back to that, do you think?
I think it really, I think it needs to, at this point, because I absolutely agree with Stella that the courts are responding, police and courts are responding to physical violence in the main. Coercive control is physical and non-physical violence. Non-coercive control is also physical and non-physical violence. It's not about the actions, it's actually about the motivation, the context. And that's what we're not getting at in policing and in court response to the problem.
Yeah, no, thank you for look, I think the idea of coercive control has been argued for a very long time as a way of conceptualising what domestic violence and violence in the family, intimate partner violence might really be about. But
we're still not good at articulating it.
We're not good at articulating it, and there are as many problems that have come out of it potentially as ways in which it has clarified the explanation of some things. Lee, I'm going to come back to you and ask you to describe some of those particular problems that have arisen, and I'm going to leave some of the solutions that you suggest to the end of the discussion. So if you could just tell us about some of the ways that this has played out, and then I'm going to get to other panel members to talk about some of how things have played out in Australia with what we've looked at.
Absolutely. I want to put a pin, though, in the idea of criminalizing coercive control, because I think that is one of the big things that's happening across the world now, and I think it's deeply problematic. And so I want us to, at some point, if we can, come back to this question about whether criminalizing coercive control specifically is a good idea. Going back to where I was, there are a number of reasons why the criminal legal system is a bad way to deal with intimate partner violence. So some of them have to do with, so let's back up a step, right? Because one thing that people ask all the time is it working? And it depends on what you mean by working, but I think by any measure the answer is no. And so if the measure was, are rates of domestic violence decreasing as a result of the criminalization of intimate partner violence in the United States, the answer is no. Rates have decreased, but so has the overall crime rate, and in fact, rates of intimate partner violence have decreased less than the drop in the overall crime rate, while at the same time, the United States has been pouring hundreds of millions of dollars into courts, police, and prosecutors. So it's not working in that way. It's not working as a deterrent. There are lots of reasons why that's true, but I'm just going to make that blanket statement, and if people want to challenge that, I'm happy to come back to it. But what's really problematic about it is I think that it creates the conditions that lead to intimate partner violence. And let me just give 3 examples. So 1, the research tells us that under and unemployment of men is highly correlated with intimate partner violence, probably the most highly correlated risk factor for intimate partner violence. And in the United States, if you are involved in the criminal legal system, it makes your ability to get employment, to keep employment, almost impossible. There are barriers to employment that exist simply as a function of being involved in the criminal legal system, whether or not you're incarcerated. And certainly if you're incarcerated, that's a huge barrier to employment. So the very thing that we are using to address the violence is something that is driving the violence. Secondly, community-level factors are highly correlated with intimate partner violence. So low-income communities, unstable communities, communities where there's a great amount of flux, have higher rates of intimate partner violence, which are the same communities that a lot of the people who are being brought into the criminal system are coming from. And so at a time when you would have wage earners caring for children, creating economic stability within communities, we're taking people out of those communities and putting them into the criminal legal system. Again, it's a driver for violence. And then the third argument that I make is about trauma and the impact of trauma on intimate partner violence. Trauma, particularly post-traumatic stress disorder, is highly correlated with the perpetration of intimate partner violence. And yet, we use shame-based punishments that are likely to create greater trauma in order to respond to violence. We send people into environments that are deeply traumatic. American prisons are horrible institutions where people are likely to be witnesses to or victims of violence, where they experience traumatizing things, and then take those back out into their communities and into their relationships with nobody providing them with any kind of support in dealing with that trauma. So again, this punishment that we think is going to stop violence is actually going to drive violence. There are a number of other examples I could give, but I think that gives you a sense of why I'm making the argument I'm making. And I should be clear. When I say criminalization is the primary response to intimate partner violence in the United States, we've made that clear through the way that we fund services in the criminal legal system and the way that we focus our attention. So research in the United States is all around the criminal legal system. The Violence Against Women Act, which is our signature federal legislation about intimate partner violence and other forms of gender-based violence, disproportionately funds the criminal legal system. Those are the messages, those are the incentives that we're creating. But I do think in the Australian context, even if that's not your primary focus, there are problematic pieces of criminalization that I see popping up. So I was here 3 years ago, and at that time, and my message was, please don't do what we have done, because it's a bad idea and it's not working well. And so when you look at pro-arrest policy, for example, and you see that arrests of women are increasing, particularly arrests of Indigenous women are increasing, that's a problem. And I think it's something worth paying attention to, because even if criminalization isn't your primary response, it is nonetheless a problematic response, and it's not doing the work that I think we hope it will do. Then the last piece is about this prosecutorial misconduct, that prosecutors use the criminal law to force victims of violence to cooperate with prosecutions that they may not want for various reasons, that those prosecutions don't make them safer, they undermine their relationships, they may keep them entangled with people who they had no further entanglement with. And prosecutors use deeply problematic practices in the United States, like jailing victims to compel their testimony, that I think are a very quick step from evidence-based prosecution. So to the extent that evidence-based prosecution has taken hold here, as it has in other places, there's not a far distance to go before you start to see prosecutors saying, it's important that we prosecute these cases because they create such damage, And we're going to do that whether you want us to do it or not, because our responsibility is to the state, not to the individual. And so the victim becomes sacrificed to the greater goal of keeping the state safe and this fiction that, in fact, the prosecution is doing that work.
I'd like to say thank you. But I mean, it is quite terrifying. And having read one of the accounts that you give about a woman who had the relationship had finished, she didn't want to go ahead with any prosecution, and she ends up in jail for a significant period of time because she's a witness who doesn't want to be there, and the documents that brought her there had been faked. And we won't say if there's someone else in America who likes to use that term, but the idea of a prosecutor faking things, as someone who teaches ethics to lawyers, does not make me feel very happy about ethical behaviour.
And they do so in the name of saving women. And I think that's problematic both in that it assumes, as Heather said, that these are victims who need saving, who are not actualized enough to make choices about their own lives, and that there is some greater good that is obtained by doing this so that the ethical rules don't need to apply. So I think problematic in every aspect.
Look, I'm going to move from those experiences that you've described about what's happening in America and ask Thelma to make comment as the practitioner here at the table, someone who is walking into the courts and representing people in relation to domestic and family violence. Some of these issues that are being talked about where the victim becomes the one who becomes the target of the system, and as someone who is and who has worked with Aboriginal and Torres Strait Islander people, the idea of someone else charging in to save women is probably something that you've seen. And I'm just wondering, what do you see as what is happening, to expand on your opening comments about that neither the criminal system nor the civil system is really providing answers in your community?
I think there's a bigger picture topic when we're talking about Aboriginal and Torres Strait Islander people. And I mean, we're probably the only country that has a constitution where our First Nation people aren't formally recognised in that constitution. We talk about trauma. We've seen that raised and its impact. Aboriginal and Torres Strait Islander people have, through progressive policies, suffered and sustained intergenerational trauma since colonisation. Our histories, our storytelling, our culture has been successfully disseminated since colonisation. You know, when we're talking and looking at the impacts, and we're having a very relevant discussion now in the national space around closing the gap targets, what our Coalition of Peaks are doing in negotiation with our governments to improve better social and legal determinants. I think we need to pull it all together and realise that the system we have has failed with respect. We have a policing system, and we haven't touched on this probably overtly, but I'm going to call it for what it is, that is racist with respect. I've been working as a practitioner for 20 plus years. I can guarantee you that I can walk into a store, I'll be the only one down an aisle, and next thing you'll hear will be security check on that aisle I'm in. So racism is at the heart of a lot of drivers. It shouldn't happen, but it does. And I think these white elephants in the room need to be pulled out and need to be spoken about. We are all mature. We've all grown together. And it's time to face a number of things that hold us back. And these bigger picture issues that impact upon Aboriginal and Torres Strait Islander people particularly also have relevance to other communities within our society, such as culturally and linguistically diverse peoples, peoples who identify from the LGBTIQ community. not being seen, being minimalised. And I've practiced for 20 plus years, and I wonder why I keep practicing when I haven't seen shifts. And I think the criminal legal system, I love the practice of the law, I really do, but the criminal legal system is not the place to address what I see as bigger social issues. It needs to come from policy and social reform. What are we doing as a society, and where are we going, and where is the courage of our so-called leaders in this space to lead this discussion and change, and to acknowledge that what we have now, the frameworks we have, don't work. And there's no time then now to change it.
Yes, so that's right, these underlying issues, when we keep on looking at the law, we're looking at the completely wrong end of everything that is going on, and we have to look right back at how we improve our health system,
Yes.
our education system, our the distribution of money through Centrelink, the policies that are in place.
That's
that
correct,
are in
Zoe. I
place
mean,
there.
I think, and Wendy, you might have some comment on this. I train my staff in my practice. The law is the back-end sausage factory response, all right, and it's designed to process. And that's not to disrespect the work that happens there, but it has a statutory framework that judicial officers and lawyers going into that courtroom, coupled with our ethics, need to abide by. That's the back end. What are we doing at the front end? That's where the real investment needs to be. Up the front, we need to pull that significant investment out the back and start putting it at the front. But that's the hard end, and that's where our politicians and our leaders don't want to address, because it is multi-layered.
Yes.
And we're going to have some uncomfortable conversations, but we need to have those uncomfortable conversations, or else you keep perpetuating this cycle.
I think I agree with you, Thelma, and I think that even more than investing up the front, it's about eliminating the structural inequalities that need that kind of investment. I mean, the law really is the back end aimed at achieving civility in circumstances of inequality. When people are resisting their oppression and they're being punished. So the legal system is really a mechanism to try to achieve the status quo, maintain the status quo. I think that's the problem, and I agree with you, we should be investing at the front end, but if we could dismantle the structural inequality, racial, gender and socioeconomic inequality, then perhaps we wouldn't even need the investment up front. I mean, that's the ultimate problem. That is probably the hardest to achieve.
Well, and that's why you don't get change, because people start to look at what you would have to do to really make change, right?
Yeah.
To combat structural racism, just combat structural economic inequality. And they say, well, we can't do all of that, but we can cage people.
Yeah.
Or we can issue orders that they may or may not follow, and they may or may not. Right.
Control.
And so that conversation, because it feels so big, makes people feel completely powerless. And it leads us to stay exactly where we are.
Yeah.
And I think that one of the ways in which our system has shown that they're doing something, and Heather, you mentioned earlier, like the Queensland Task Force report that came out in 1988, I think, or 87, 88, Beyond These Walls. Of course, contained in that was chapter after chapter about holistic responses that you're talking about, Thelma. But what's the one thing that we all know came out of it? It wasn't called, what was it called then? Just the domestic violence,
domestic and family violance.
No,
domestic violence
protection,
in brackets family
protection
act.
Because they wanted to make sure that that everyone understood that this was not about separating people, but about keeping families together. And quite a lot was said about that
Protecting
in Parliament
the family,
as well.
Yeah.
And so the word protection was carefully in there. I was going to say more, but I'm the facilitator. Stella, I'm going to come back to you. I was just going to offer Wendy an opportunity to just talk about that sense of where the law really sits in this, and that you've talked about the importance of all the people around on a court day and how much difference that can make. But I mean, that's the people who are there on the day when you're in court, and it's all the people who I guess should have been there months and years before.
But it's just what Stella says, that's the back end, that's just the structural end, the legislative provision to in a supposedly preventative situation, but the reality is the things that cause domestic violence, which is the socioeconomic issues that are part of a whole different debate, really, and the resources and funding for that, the education, are not matters for the court.
Yes, I mean, well, of course, and of course, I mean, I guess that what we're trying to do today is to show that they need to actually be a part of one debate and to put this panel together. But we know that at the end of the hour to hour and a half we get to spend together, we probably won't have resolved this completely, but we certainly want to put some noisy solutions out there. Stella?
Yeah, I agree with everything everybody is saying, that the law is so and brutal in its operation, and working on the basis of shame and the counterproductive construct of basing something on shame. I want to suggest, like, having all of that, and I want to suggest, though, a couple of things that I think we do still need to be not letting the law off the hook, almost, is a way that I see it. And starting from, when we say what the solutions are that need all of the resources that we have, the collective resources that we don't want really to put there, but if we want the problem to end, we need to put them there. And really primarily it's housing. I think it's also racism. It's also the gender, the status of women. So, and they're made up of cultural ideas, non-Aboriginal cultural ideas, about the status of different races and ethnicities, the different genders. They're the ways we work. They're the ways we think. And so resources also into, ways that will recognise that it's not a neutral thing either to do this or provide houses. It is in a context of racism. It's a context of diminishment of women, in the status of women. And having said that, I think I'm getting at the idea that this is happening everywhere, including the courts. This lack of understanding it's not a neutral idea. It's not a neutral institution that is doling it out or not doling it out. It's a massive part of what we are as a society. And so I say courts because that's where I'm sort of heading. My idea is that those institutions are also doing it. Like, they're also part of everything that we're actually trying to address. And so, and I'm not suggesting you are suggesting that, but the idea that we just turn away from the law and sort of think that, the rest of we're going to solve it somewhere else. So, and my thinking then is that in the area where women are before the court as offenders is an area where, and offenders on serious charges, is an area where we're not going to be able to turn our backs for a long time. And that's where work can be done, because it's the safe place, safe in the sense that all the unintended consequences have already happened, and here is where we can focus on how the understanding level of it, the sort of pushing the envelope for how people are understanding it. And I'm, thinking of the racism that is evident in the way Aboriginal women who've killed their partners are dealt with, and the lack of understanding of gender, and race and other intersections that are so evident in the way that people are, the women are dealt with. So it's just an addition to what I agree with you that it's such a wrong place for us to be going, a wrong place, but it's part of the place, and so it can't be ignored as an institution we need to address.
Look, thank you for that, Stella. And I mean, the reality is we do live in a world at the moment where the law is going to continue to play a role in domestic and family violence. So we do have to get it as right as possible as we simultaneously try to also address these other issues. And I do want to come back to some of the specifics of your research, but when you're looking particularly at women who've ended up charged with homicide of an abusive partner, those women will end up in the legal system, and we have to make the legal system work for them. Lee, perhaps we maybe we'll start to talk a little bit about what you see as some of the solutions out of what you've talked through, and we'll talk a little bit about that around the table, but I also want to invite some comments on other issues and come back to Stella on the specific things she's been talking about. But Lee, what do you see as some of the solutions forward then through this?
Dismantling structural racism and economic inequality, and then we're done, and we can move on with our lives. So I really appreciate what Stella said. And it's interesting, in the United States, there's an entire prison abolition movement that I am now a part of, which I never really expected to be. And if you had told me 25 years ago when I started doing this work that that's where I would end up, I would have told you were crazy. And so I think our work is moving on two tracks. One is about how do we get to a place where it's not the legal system, and then given that it is the legal system right now, what can we do to make it better? And the solutions that I come up with in the book really look at both of those levels. But broadly speaking, I have argued that we could better deal with domestic violence through economic policy, through community-based interventions, through public health policy, and by using a human rights framework. And so just some of the concrete ideas that come out of that are things like increasing the minimum wage so that people have a living wage, so that they don't have the economic stress that creates, oftentimes, leads to intimate partner violence. Because we live in a world still in which masculinity is largely defined through the ability to provide. And when men are unable to provide, that provokes intimate partner violence. So thinking about how we deal with deindustrialization and globalization and the impact that that has on wage-earning men and how that drives violence, I think, is a big part of what we need to be doing. Thinking about how we create economic stability for women is an equally important part of what we should be doing, because it's important that people be able to leave abusive relationships and have the ability to live. My experience has been that many of my clients don't want to leave their relationships, and there are lots of reasons for that. But when they do want to leave and they can't, that's almost always about economics. And so dealing with that issue, I think, is incredibly important. Thinking about prevention, right? So I agree with Thelma completely. The legal system is a processing system. What it does is it takes the hundreds of thousands of cases that come in and just does something with them. I don't call it the criminal justice system because I don't think any justice comes out of it. So you realize that early on. But what we have is a processing system. Instead of processing things on the back end when harm has already happened, we need to be thinking about the front end. And so some of the things that I talk about in the book include adverse childhood experiences and the impact of adverse childhood experiences and how we prevent those experiences from happening using things like nurse practitioner partnerships and other kinds of work around child abuse and neglect. Thinking about dating violence education at the middle school level, at the younger kid level, so that we're talking about these issues early and often. Thinking about edutainment and the ways in which we can get messages about the use of violence and the importance of nonviolence into the world in ways that don't feel preachy, but really help people understand them. And then thinking about population level interventions, which for us in the United States are all about two things: alcohol and guns. A lot of times in the anti-violence movement, we don't want to talk about alcohol because people see it as an excuse It's not an excuse, but it is an explanation, and I think it's an important one, and we need to be talking about it. Because someone is drinking doesn't excuse their violent behavior, but it does make them more lethal, and it does make them more dangerous. And until we talk about that, we will continue to have this problem. And for us in the US, guns are a huge issue that we need to be talking about. Not, I know, for you as much. Thinking about community-based responses. So thinking about community accountability. How do we take responsibility for violence out of the hands of police and prosecutors and put it back into the community? And that's a really complicated issue. People come from communities that in some cases either facilitate or encourage violence. So how can putting those problems back in those communities be a good thing? And so there's a whole conversation to be had about that. I talk and write a lot about restorative justice, and I'm happy to talk about that, but I want to be really clear that that's only one small piece of a much bigger set of interventions. Restorative justice in the context of intimate partner violence done correctly is not going to be appropriate for the vast majority of cases, and it's certainly never going to replace a criminal processing system that in my world is dealing with, there are 800,000 incidents of domestic violence in the United States each year. We cannot do RJ for 800,000 incidents. It can't happen. And then thinking about a human rights framework, which expands our ideas about what the kinds of interventions should look like, from just prosecution and punishment to prevention and providing reparations and protection. So kind of changing the way that we think and frame these issues. And so in the book, I talk a lot about kind of US-specific interventions around a lot of these issues, but I think that they, again, have purchase here as well, particularly in thinking about what do we do at the front end, as Thelma has said, to deal with these problems both individually and structurally, so that on the back end, we're not using this ineffective and reactive response.
Thank you. Yes, these are. That's right.
Just
Okay.
that.
We'll as soon as we finish this, we'll start.
We'll do it. It will be fun.
We'll start work on that. Thelma, if I could come to you, and I think that the issues in your community are exacerbated by the racism that we experience in Australian society, and that racism percolates down to all kinds of aspects of the system, whether it is policing or courts, or, as you say, the way that security works in a shopping centre. I'm sure that one of the things that we know is these perceptions or assumptions about Indigenous people that happen within the system, and it means that the way that a woman who's Aboriginal might end up being treated in a particular situation is going to be different than in that exact same situation, but if that woman had been a white woman, and everyone is then going to imagine that somehow or other this happened in a different way or see it differently. What can you tell us of your experience about that way in which Indigenous people are treated within the court system or within the legal system, and how might we start to move past that?
I think that's a very valid question. I think what I saw in my criminal law experience, especially in representing defendants who are accused of murdering Indigenous partners, you would see the difference in the media response, okay? And there was a complete invisibility of the Aboriginal and Torres Strait Islander victim. And the excuse put forward was, well, we can't, for cultural reasons, name that victim. But that doesn't stop you from running a story about what the victim experienced, what she went through. It doesn't stop you from actually trying to tackle what I see in community, what I've learnt in my experience. There's a normalisation of violence in Aboriginal and Torres Strait Islander communities. But then it feeds into this bigger misconception that all Aboriginal and Torres Strait Islander people are violent, that Aboriginal and Torres Strait Islander men are violent, and that's the only type of partner that an Aboriginal and Torres Strait Islander woman will have, and she's experiencing violence from an Aboriginal and Torres Strait Islander man. Now, that's completely not true. And it's completely disturbing that these perceptions or stereotypes still exist in the 20th century. And it really paints the type of service responses that some of my clients have experienced, or why they won't make a complaint to police, why they won't leave, or there is in some more remote and rural communities a lack of a complete police presence. All right, that police station is probably a couple of hundred, a couple of thousand kilometres down the road. They're completely isolated. So I'm hoping that's answered.
Yes.
I mean, it's a tip of the iceberg.
Yes, yes.
It's the tip of the iceberg of what we're dealing with here and these stereotypes. I remember first working in courts for Aboriginal and Torres Strait Islander people, and I'm glad there's been a shift in judicial perspectives. I'm sorry, Wendy, I'm going to have to say this, but there would be perceptions from the bench about the truthfulness or lack thereof of my clients based on, one, whether they're a battered woman. I used to have the comment all the time, Miss Schwartz, your client's nothing more than a gilded lily. She's gilding it now for me. That was my Northern Territory experience, which was not uncommon to my Queensland experience when I first started out in far north Queensland.
Can you tell us, so whenabouts is this, Thelma, in terms of when did you start practice?
Oh my God, it's 20 years, so this would have been in my first 2 years of practice, so 18 years ago.
So around the turn of the century, this is what we're still dealing with in Australian courts. And by the way, that's the turn of the 20th to the 21st century, not the 19th to the 20th or the 18th to the 19th.
I mean, there's been a slow progression. The courts have got better, but I remember when I went through the court system as a young lawyer, the questions around, why are you wearing trousers in my courtroom?
Oh, goodness, yes.
So I'm part of that brigade.
Why were you?
Because it was my choice.
Oh, truly.
My body, my control. So I was part of that. I was part of the women who came into the practice, and it was very much, the law is not, the practice of the criminal law is not an area for women.
Yes.
Why aren't you practicing in commercial or family? All of those types of areas.
Can I ask you one more thing, and then we'll move on, because I think that we're going to have a chance for each person to make one more comment. But you talked there about diversity in the judiciary, and there are efforts being made to create a more diverse judiciary. Certainly when I was at law school, because I'm a much older lawyer than you are, there was not a woman on the bench in Queensland at that time, or at any level, and things have changed dramatically in that regard, although we're not at 50%, but things have changed. But in terms of Aboriginal and Torres Strait Islander lawyers on the bench, we still have, very limited numbers. A couple of magistrates, Nathan Jarrow recently up to the District Court, and Jackie Payne, of course, has been on the Magistrates Court for a very long time. But actually, in terms of other cultural groups, very poor representation of people from culturally and linguistically diverse groups still in many ways. Do you think that is going to change, and do you think that can be a contributor to change?
I think if we make it accessible and truly reflective of our society, that will assist. But it comes down to when we're looking, I think you've got to be really careful in that you always need to ensure that your appointments are based on merit. I agree that we need to see increased numbers of Aboriginal and Torres Strait Islander people primarily getting on the bench and in positions of control, as are other people from culturally and linguistically diverse backgrounds, to truly reflect our community. Because, it's evident that we work within very much still a very Anglo-Saxon framework, and it hasn't been, it's slowly coming around. I'd like to say that I'm a glass half full person. I have hope because there have been changes, but we need to invest in training of our judicial officers in terms of equality, diversity, all of those types of things, particularly in dealing with Aboriginal and Torres Strait Islander people, and looking at different ways. I know that there are successful Murray Court programs that are run here in Queensland, and I've been involved with in Cairns that work really well and effectively. So I'd hope to see change.
Can I just say one quick thing about that? So the argument has always been made that if you had greater representation of women on the bench, you would have better handling of domestic violence. I don't think that's true. And in this past semester with my students, we had the opportunity to go in front of several different judges. We went in front of an African-American woman, we went in front of a white woman, we went in front of an African-American man, and we went in front of a white man. And my students were horrified that the best experience that they had for a victim was in front of a white man. So I think that representation is important for lots of different reasons, but assuming, and I don't think Thelma's doing this, but this is just a point that I always make, assuming that representation will equal better treatment of victims of domestic violence is not true. It's not so. And so that the idea of training, and more importantly, I think the idea of appointing people to the bench who have an understanding coming in and have a sensitivity coming in to these issues is absolutely essential. In a U.S. context, I always say the same thing, which is I can give you 4 words about why that's not true, and the words are Clarence Thomas and Sarah Palin, which are primary examples of why we have to be thoughtful about who comes to the bench. That representation matters, but it's not everything.
Yeah. Can I just say too that and this is a general comment for us in our discussion, it's that to really know the multi-dimensional directions that we need to work in and the multi-directional purposes for things we do. Like I noticed that Thelma was saying it will assist in the sense that it will assist in the sense that it can, even apart from the individual's performance, it can send normative messages. It can change the norm, and we need to be thinking as analysts, as policy critiques and in all sorts of positions we are about how that's going to operate on different levels. So that's all. So it's not like because one person is bad and because. And the other thing I was going to say, just one quick thing about that is that in my work as well, what I perceive, I call it a sympathy. There's a sympathy operation that can happen. In the sense that now women are not so often, but Aboriginal women are more often convicted of murder, and most are convicted of manslaughter. But you look at the machinations of how that's happened, and it's actually what I call a sympathy. It's like sympathy. We're so sad for you. This is such a tragic thing that has happened to you. But it's not about justice, So I think even when you have a white man who's often safe enough to be sympathetic or whatever, there can be an orientation that provides the position in which I can be sympathetic or brutal or whatever, right? But sympathy is not what people, what we need.
It's not justice.
We need justice.
It's not justice.
It's not justice.
No.
Look, I mean, yes, everything that everyone has said, the research I've done about diversity in the judiciary, it's critically important. We have to have different faces and different experiences, but that doesn't mean that one can expect that that each judge then operates in some kind of stereotypical way that we hope of their gender, their race, their class. It is so much more complex than that. I do a 2-hour lecture on this all the time, so I could talk forever on that, but I won't. To move on, Heather, I am going to ask you to comment on and go back to that question of coercive control that we didn't finalise, and for you to take that into some solutions. But I suppose, so one of the things that I found about my reading and thinking about coercive control becoming a very central discussion in how we deal with domestic and family violence. So it was there right in the beginning, right, like the kind of era that Lee was talking about before, and then we've kind of come back to it in an attempt to I think from what you read, the policy idea about it is to try to bring us to understand, and I think it's something that you talk about, what is the difference between a fight or an argument and what amounts to domestic violence. But I suppose that, so we see on the one hand this can become highly problematic because we can see that police won't look at that distinction and may make all kinds of decisions where people end up being arrested for something that just simply isn't domestic violence, and that this might happen particularly in Indigenous communities where police are not understanding what they're seeing and where they're making assumptions about people involved. On the other hand, that definition finding itself, or those words finding themselves in statutes, in the domestic violence legislation and in the Family Law Act, there's a concern that it can tip the other way as well, and that you end up with, particularly in family law, women in the family court desperately trying to find a way to marshal evidence that proves that the experience that they've had amounts to coercive control, because if it doesn't, it mightn't fall within that piece of legislation's definition. So I wonder where your thinking has taken you on how these things play out and that expression.
I'm very mindful that what I'm calling for in my book for a distinction between coercive control and fights is comes with high risk of taking us back to what Lee talked about earlier, the 60s and 70s, where the response was to get the perpetrator to take a walk around the block. I mean, back in those days, there was a recognition that the perpetrator was nearly almost exclusively male, but increasingly we're seeing, because of this formulaic response to domestic violence equals a relevant relationship and an act that is prescribed in the legislation as an act of domestic violence, and so that it's much more complex than that. First of all, I don't argue for an offence of coercive control. I don't think it's helpful to have yet another law that's problematic. What I'm arguing for is the need to develop the skills and resources, the tools, to better understand and articulate what is coercive control. We've always talked about it, whether it's in the US or in Australia, but we talked about it as power and control. It was always, the term was power and control, power and control. I think that Evan Stark's enunciation of an attack on autonomy, liberty and equality, an attack on personhood, it goes to the essence of what domestic violence is. What I, as a young white feminist, set out to deal with was that kind of abuse of women, that control of women. So the kinds of violence now, though, that we're seeing being brought into the criminal justice system, the criminal legal system, particularly for Aboriginal and Torres Strait Islander women, their use of violence, and racism occurs in many different ways. So one example I want to give is it's actually a scene that is set out in the beginning of the book to sort of identify the problem that we have that I'm trying to address, and that is that a couple, an Aboriginal couple on the Esplanade in Cairns, fighting, throwing punches at each other over the top of a rubbish bin. So they've been picnicking in the park with a group of friends, and this fight breaks out. They're having this fight over the rubbish bin, and it's caught on CCTV. No one's made a complaint. Peter, these are the names I've made up for Thelma and Peter in this scenario, is Peter's never called the police. Thelma's, he's not at risk of injury, or he's not being dominated and controlled by Thelma. And yet this is her fifth breach. These scenarios like this, where people are just cycling through the system, they're being breached time and time again, the violence is not ending, it's not making any difference to their life, they're not engaged in the process or the system. And meanwhile, I also argue that for those who do need a considered legal response to address coercive control, are not getting that, because the police and courts are so busy prosecuting and dealing with the volume of cases that are being pointlessly prosecuted because it's not making any productive difference to their lives. And there are a number of reasons why there's no engagement. Partly is because of the lack of legitimacy seen by those people in the mainstream legal system. but it's also, for some of them, in what I call chaos context violence, where people are engaged in high levels of violence that could be corrupted forms of contemporary Aboriginal dispute resolution, or it could be fights that are, coming out of, extreme kind of frustration and, expression. It's expressive violence. It's not instrumental violence in the way that it's about general control over the life of the other. And so they're the cases that perhaps need a completely different response. A legal response is not helpful. Those people need ultimately structural reform. We need to deal with the structural inequality. But in the short term, some of those people might benefit. They need to be constrained because the violence is dangerous. People are being, injured and harmed. And one case I talk about in the book from the police reports of breaches, a case of Doreen. She also was charged with breaches on 5 separate occasions, using extreme violence. And the last incident in the police records that I have, she stabbed Sam in the neck with a broken bottle. Like, these are really violent cases. So I'm not saying that it's less serious, it's less harmful, it needs a response, but the criminal justice response or the criminal legal response is absolutely having no effect. What that woman in that situation needs is perhaps a medical response. Certainly a housing response, certainly, interventions that support her and enable her to live the kind of life that I'm sure that she would aspire to. And what I say in that regard, in regard to that case, is that this is not an expression of power; it's an expression of powerlessness, and that we need to get better at distinguishing between coercive control and non-coercive control, not to create an offence of coercive control necessarily, but to understand that there are different phenomena that need different strategies.
Heather, I mean, that research that you've done is so important and dives into something that really makes us all think about stuff that we've been thinking about for a very long time, and to make sure that we're not trapped in particular ways of thinking about it. I'm going to turn to Stella, because we haven't given you a chance to just unpack very quickly in a few minutes that I'm going to give you. Something then it picks up on many of these things, the particular idea about why our criminal legal system makes it so difficult for women to raise self-defence when they have been a victim of extreme violence and they end up responding with homicide, and that idea of social entrapment that you talk about. Can you give us in a couple of minutes a kind of summary of where that has taken you to?
Yeah. So the question is why it becomes so difficult. I think it's lack of understanding, but what might be good to do is to describe again that social entrapment kind of approach, and I'm seeing this fitting in two positions in a way in the function of it, and it's in response to Heather, or in continuation from what Heather's said. I see it in what I've already said, that we are in the criminal justice system at the moment with women being prosecuted for various homicide offences is where I'm looking at. And the other is this, what I've said before too, that we need to keep talking about understandings of what we're seeing. So the social entrapment framework would start with, and it's actually shorthand as I see it, and we shouldn't be using the shorthand, because I think coercive control is actually reifying, it's becoming a nugget of an idea that we're putting all of our understandings in a way that is not useful. What I see is that dimension is more its content, and to this extent I do really see it the same way as you, Heather, that it is about, we need to be looking for the control, domination, or a sense of entitlement by someone over another. The sort of sense that I can live and I can make decisions for you, right? So that's the bottom line of it on an ongoing basis.
Yeah.
So if we have a construct, a relationship or an interaction where that's happening, that's what is there, and that can involve. It often does involve a strategic isolation of someone. But I don't know that it needs to be positively intentional. I think it can be a way of living within this culture that actually expands to the point where I can decide for you where you go. I can, encourage you to stay home, and then I can make you stay home, and then I can ring you up a few times in the evening to check on you, and then I can ring you 20 times in the evening to check on you, and then I can hit you because you didn't respond to my phone call, sort of thing. So it is about, so it's a continuum of that, but it's the fear and isolation that goes with that. And then, as I said before, and this gets to the idea that, who makes the violence? It is it is that construct of two people, but it's also what we are doing in relation to the violence. Like, who is endorsing the violence, and how many implicit ways are we endorsing that violence by not recognising it, by not responding to someone disclosing about the violence, by not asking about sexual violence when someone's disclosed about physical violence, because we don't ask about sexual violence. Sexual violence is embedded often in a relationship in a way that we still do see as a normal, and the shame factor works there, so we don't know those things. So there's the people around the people who are suffering the violence, and then there are the agencies, and this is what we've been talking about all afternoon, really. Like, we're not, as a collective society, we are not responding to that violence in a way that is making that person safe. And we need to see that as part of the situation that a woman has been living through in her context before she's being tried in this homicide context. What did the society do that was that failed a woman being able to, we call it leave, but it's a different thing often. And by the way, just as a aside, I am really, right up. So that's the second, and then thirdly, as I said, it was the structural questions that we bring in. So perhaps I'll leave it there. Yeah.
Thank you for that. That it is the perennial question, isn't it? That I'm sure that all of us who work in this area get asked by people who don't. Why didn't she just leave? And I'm sure we've all been asked that question, and the answer is such a complicated one.
It's the wrong question.
That's right. And in a way, that's what your research focuses on. Well, look, we have come to the end of the time that we have available. I think it's been a fabulous discussion, and we've had so many different perspectives from telling us what's going on in the United States to what's going on in far north Queensland in our Aboriginal and Torres Strait Islander communities, to what's happening in Western Australia, and what's happening, the view from the bench. We've really, I think, covered such an array of circumstances, and at the end of the day, I think what we're saying is the law can never be the solution here. It can be a part of the solution, but it does sit at the back end of the process, and we're all encouraging lots of efforts to go into ensuring that we address all of the social issues which happen at the beginning of the problem and lead to families in which violence can occur. Thanks everyone very much.
Thank you.
Thank